My name is Laurent. I'm working for the European Commission, more specifically the Joint Research Center of the Commission. We are providing scientific support to the other DG of the Commission whenever there is a policy development on various fields. And the GRC is, let's say, heavily involved in the, or let's say, contributes in a determinant way to CPDP. We are organizing 2 sessions. This is the little advertisement. One tomorrow and another one on Friday. And we are also supporting 6 of the students, not all of them are around here, among the students who have been selected for this academic section. We are supporting them. For the speakers, I would like to remind you 2 important things for CPDP. First of all, you have to respect time, and I will be very strict about that, especially because it's running and I'm speaking too much. And the other point is it's supposed to be a constructive and provocative talk. So please focus on the salient points of your talk, of your paper, in order to have an interaction with the audience for attending this this session. So the most interactive session we have, the better it will be. Okay, so now maybe it is so the first speaker.
The last one, tracing suspicion.
Yeah. Okay. So roughly you have, let's say, 10 minutes, and then we will take 1-2 questions. Remotes, I don't know, that was not with. Yeah, look, yeah, you understand it. That's the point.
It would be nice.
Yeah.
But I can just put a few
Yes, yes. Oops, voilà. No, there was a remote.
Let's give it a try.
Okay.
So,
Let's go.
thank you. Welcome. I'm Vlad Niculescu. I'm a PhD candidate from Maastricht University and lecturer at Erasmus University. Also on behalf of Jason Brigmore, assistant professor at Erasmus University, I'd like you to give a talk on our paper on suspicion, on privacy, on automatic number plate recognition, and the police. So that's a nice thing to be in the last panel because you get to summarize things. I will do it in a very brief, sketchy way, but this connects well to a whole set of panels that we have today, and I won't introduce this to the world of policing, but I will just mention that in the past decades there has been a shift in the world of policing, roughly from more reactive, investigative styles towards more proactive, preventive styles. Problem-oriented policing, CompStat intelligence-led policing, the most recent offshoot of knowledge-based policing are policing models that we've seen coming and developing. And briefly to say that these have been, so some of the practices that have been promoted by these models have been afforded as well by developments in ICT, such as data mining. We had a nice panel on internet and social media monitoring earlier today, video analytics, a really nice panel earlier, sensor networks as well. And these have been even, of course, we know we are here, privacy concerns that have been approached, of course, multidisciplinary, but one of the approaches that have been promoted lately is the approach of embedding privacy norms into the design of technologies, and these ideas have been found their way also in the proposed General Data Protection Regulation in different shapes or forms, but there is no binding obligation to implement particular solutions over others, and there's also, as we've seen throughout the whole day, not straightforward implementation of these ideas. So this is for me the background on which I will be talking, because in this context, several organizations, the police as well, have taken up these ideas, have made their own implementations, have tried to answer these privacy concerns. So I will be focusing and talking more on a case study in the Dutch police, in which they look to protect privacy in automatic number plate recognition system that they have. They use it as a sensor network, so their conception is of a sensor network includes ANPR, but it goes broader. And they combine ideas and insights from knowledge-based policing, their version of it, with profiling of suspicious behavior, applying profiles to suspicious behavior as a way to improve privacy protection. I will be talking briefly about our approach to study suspicion as a particular angle to understand privacy breaches. By drawing on ethnographic research I've performed the premises of this project and taking an actor network theory inspired analysis to make sense of the data. Depending on time, and I've understood that you'll be strict on this, I will share a bit a few of the findings and that we've been analyzing in our paper. And perhaps this will not be shocking findings, but they do point to some of the ongoing risks for privacy that this kind of technologically mediated practices still pose, even in this kind of projects that have made a serious effort to tackle these concerns. Okay. I won't be going a lot in detail about automatic number plate recognition, but perhaps it suffices to say that it's a technology that enables the identification of license plates of vehicles in traffic in real time. Object character recognition is the technology, so video analytics. It cross-checks this information with a whole set of databases. I won't go in detail, but here just concentrate on a particular decision that some arrangements in certain contexts have, is to store all the traffic data, enabling data mining and say offline analysis, or not store it, but just perform applied profiles to the live traffic, requiring a small amount of time that data has to be stored. And this is the approach that I will be describing in more detail in this project. So, the Dutch police applies profiles to ephemeral sensor data. This is a paper published from this project. They claim to use no persistent databases, and they delegate police knowledge from different branches of the police that they come together, and they delegate them to real-time automated profiles that run on ANPR. Perhaps the best way to illustrate this is by means of an example. I'm not sharing here police secrets. It's an example that they gave is how to catch canvas cutters, thieves. So these are, in short, thieves that cut the canvas of trucks, of lorries that are parked along the highway. And at some point, this is producing apparently a significant amount of costs. And at some point, they said, let's do something about it. So they've summoned different branches of the police, the traffic police, neighborhood police, administrator of parking places, and they've shared the knowledge that they had about this phenomenon. And they've come up with the conclusion that these thieves perform particular behavior to do their deeds, so to say. They hop around parking places with a car that's not known a priori to the police, so it's not spotted by ANPR, it cannot be included on the list. They hop around, they shop for lorries that are loaded and unattended, and that's the behavior that they've delegated to an automatic number plate recognition system, to a profile that looks for this particular behavior. Say the car is spotted in an interval of an hour in more parking places. Now, they claim that this way of working, so sharing knowledge between branches and delegating automated profile, is minimizing unjustified privacy breaches of traffic participants because it implements rigorously a minimum storage of traffic participants' data, implementing the principle of select before you collect. Also, in addition to this project, the notion of revocable privacy has been combined here because, as you can imagine, to assess if a certain traffic, a certain car is performing this behavior, it's a covered, you need to assess that over the period of an hour. So your data when you go in a traffic parking space could be analyzed as well. So to even minimize further, they encrypt the traffic participants' data unidirectionally and release it. So I'm briefly explaining the notion, it's much more complex. Revoke the privacy only when the profile gives a match. They also claim this way of working deals better with sensitive discriminatory categories because what they are profiling is the behavior on the traffic, and they do not use identity attributes because they don't use persistent databases. So they just have a spatial temporal behavioral profiling. So what is our approach to this project? This project is part of a bigger vision on policing, and particularly the use of high technology in policing that is nicely captured in this document of Policing Evolution by Dutch Police in 2005, in which high-tech solutions are the key to enable the police to prevent an unnecessary infringement in the privacy of people who are not under any suspicion. In light of this vision, and in order to analyze the kind of project I've presented, one can start with privacy and look at the way in which technologies are protected, but you can take a slightly different angle and start with suspicion and read this, for example, in a different way. Who is under suspicion? Depending on how it's under suspicion, then their privacy is legitimately breached. So in this light, it makes sense to study suspicion. We had a nice presentation in a panel before this on construction of suspicion, and this is because suspicion is a key influence on police action. It's of course not the only one, but it mediates in a way surveillance. As we've seen in the previous example, depending on what the suspicion profile hints, it makes the police officer do extra checking on a particular car, or so you can see it as a way in which it legitimizes privacy breaches. So suspicion, as I will also illustrate further, it's a dynamic notion. It's multiple. It can vary in different heads of different police officers. It's fluid. It can vary from a hunch of an officer to solid construction that can be delegated to a profile and even further in criminal justice system. It has various degrees of solidity. It can solidify and go back to being flexible, as we've seen in the panel earlier today as well, when they change completely depending on some new proof their suspicion of a case. Suspicion moves between the heads of officers and technological artifacts, so it's a socio-technical construct that delegates between technical and human. Okay, so it makes sense to take an aggregator theory approach to, so a theory that gives a symmetric view on the human and non-human aspects of it. So the approach that we have been taking in this paper and we are proposing is to look at the enactment of suspicion in socio-technical arrangements in policing, and make it more concretely to see how different actants are performing suspects or suspect situations, suspicious behaviors of vehicles in this case. So depending on time, I'll be going a bit on some of the findings. You can imagine with such a concept that profiling needs to be an ongoing practice. So as this officer from the project mentions, once you start profiling, you have to change them all the time. After 2 or 3 times we use the profile, they started adapting, and it's no news. But what's interesting is he also adds later, now we like that in fact, because they are driven away from their normal conduct. So the police engages in a quest to change the profiles and identifying the distinction between normal and abnormal, the deviant. And in this quest for adapting the profile, what we've seen is that even if they claim not to go for identity attributes, they creep back in, as another officer from this project mentions. When talking about a new profile that they are interested, we find this is interesting. We tell the profile to check if this is a new car, if it's so expensive if the owner is younger than 27. If this is all true, then you give a hit. Now, probably there are good reasons for having these criteria only, but you can imagine that, say, a whole possibly group of young entrepreneurs will also feature in this profile. So in this way of working performs new groups of suspects. I won't be quoting, but just to mention, there are high expectations of reliability from different branches of the police, and that field officers especially perform suspicion as a ready-made. They expect the profiles to deliver, jump when the profile gives a hit. At the same time, the designers are well aware that these are not 100% safe. This is an increased presumption of innocence. Okay, I will skip this to the conclusion. This way of working, combining knowledge-based policing and revocable privacy are promising in minimizing unjustified breaches, but given all that I mentioned and those that I was unable to read, only in applying a profile once it's operational, and if this profile draws on knowledge sharing instead of requesting data sharing. Final point, we have a choice to invest more in this kind of projects, provided that we are not undermining these self-regulation efforts of the police by issuing laws that entitle them to store the data, make more investment in knowledge sharing in police organizations, and because, as I've demonstrated, there are more values at stake, make the process of designing profiles more transparent, perhaps looking into value-sensitive design processes as a way to complement this way of working of the police. Thank you. This is an ongoing effort to trace the enactment of suspicion in technologically mediated policing.
We can take only one burning question. So if you have one burning question for Vlad on this presentation, please raise your hands. No? Is it connected to the DPET projects managed by the KNPD?
It's similar to that.
Okay.
It's
Interesting. Okay, so the next presentation. Hopefully it will work.
Yes.
The floor is yours, and the presentation, yeah, here it is. And you have 10 minutes as well. Good luck.
Okay, so hi everyone, my name is Corentin Deballieul and she is Pauline de Keersmaecker. We worked together during our master thesis on the problem of CCTV in Brussels and Copenhagen. We decided to work on these two cities because this is the places where we live, and we wanted our research to have consequences, to be appropriated by political groups, activists, whatever, to have consequences. So, according for our title, we chose towards the Panoptic city. There are a lot of criticism about this concept, so we won't go into this too much. We can talk about it later if you want. But we'll move forward. We also decided to conceptualize CCTV as part of defensive urbanism. So this idea that we can influence people's behavior by shaping the environment, placing barbed wires, fences, to have cameras and so on, and mainly in order to protect the ones in power, to protect the spaces of flows, protect the circulation of capital, while on the other hand repelling the poor, the marginalized, the racialized, and so on. So in our view, CCTV is part of this, but concretely what did we do was to have a look at the distribution of cameras within the cities, actually, especially where they're placed. And the main limitation of our research was that we had only the opportunity to focus on public cameras, while actually there are of course many private cameras which also look at public spaces. But on the other hand, this focusing on public cameras also allowed us to have a more political approach to our topic, because by looking at the decisions of the powers in place, looking where they decided to place their cameras, it also gave us the opportunity to analyze their choices. And this is what Pauline is going to explain now for the first case, Copenhagen.
So, I'm going to actually present the results we have obtained during our master thesis research. Firstly, we're going to talk about our self-produced maps of Copenhagen and Brussels open street CCTV networks, and secondly, I'm going to talk about the comparative analysis of the situation in those two case studies, which will also constitute actually our conclusion. So, starting with Copenhagen. I bet you cannot see a lot right now, so which is why I'm going to try to point out some areas. It is in 2008, after a knife attack that caused the death of a young boy in the center of Copenhagen, that the police, together with the local authorities, decided to launch an open street CCTV program for Copenhagen. The map showed here shows the publicly owned cameras that belong to the trial phase of that installation. So as you can actually see, there are not a lot of them. They're located around the city's three main police stations, here, and up here. Around the pedestrian commercial street here, where the tragic event I just mentioned earlier took place. The yellow polygons, so there and up there, the map is actually a little bit cropped, but whatever, correspond to the areas where the plan was to be further implemented later. So they are the neighborhoods of Nabel here and Tingbjerg up there. And again, the city center was part of the ongoing plan. But actually the plan was aborted in 2012. It was a police decision. They deemed the plan to be too expensive for the results it actually brought, because it had no preventive effect and was only used to solve the occasional case, so it was too big an investment for the results it brought. But if you take a look at the map of this commercial street with the cameras located in it, the devices are so concentrated that we also have trouble to see how the police could get an interesting efficiency-cost ratio considering such concentration in one limited area. You have to realize that this is just one street that is a few hundred meters. So the local political actors were quite displeased with that police decision to stop installing more publicly owned cameras in Copenhagen, but it seems that some local mechanisms still offered a way to go around this decision. For example, the 2011 amendment of the Danish video surveillance law allows municipalities to request monitoring of public spaces in sensitive residential areas. And as a result, cameras have been placed in 3 different places in those yellow neighborhoods of Nabel and Tingbjerg. These are the little green dots. I have actually no idea how you in the back can see it, but they're there. And these additional cameras created 2 new camera hubs in the north of the city, challenging the previous pattern where only the center commercial street seemed to appear as relevant study area. So it is also interesting to note that the municipality's efforts when it comes to monitoring residential areas are concentrated on 2 districts that are both designated by the government in an official list as ghettos, although this is disputable, but that's how they're called by the government. especially the big one of Noble because it is located next to the city center. So to conclude, we can point out that the types of spaces that are publicly monitored by in Copenhagen are police stations, the central commercial hub, and parking roads and squares around residential sensitive areas.
Okay, so here's the map for Brussels. Actually, all the dots are cameras. The orange ones are the ones that we have been checking on site, while the black dots are actually mainly future cameras, although I think many of them have been installed by now. So as you can see, most cameras can be found in the very center of the city, which is also the most touristic place, the place where there are many shops around. So there's really this idea to change the image of Brussels and make it a more touristic place, a more safe place. It is really part of this competition between cities to publicize their image. So what can be also seen is that there is this canal which is not so visible on this map, but around this canal are the more working class neighborhoods of Brussels, and also in these neighborhoods you find many cameras, and without surprise it's also the neighborhoods where there is more unemployment, where there is a higher share of migrants and strangers. On the other hand, if you take distance from the center towards the outskirts, then there are less cameras, and it's even to the point that here in the southeast there are 2 municipalities where there are no cameras at all. So there's a very strong spatial logic here. So what we also did was to check actually what were the urban furnitures that could be found around our cameras. So I'll go quite fast on this, but mainly what we found is that cameras monitor the main roads, the main access to Brussels. So there's also part of traffic regulation in this policy of placing cameras. But the other thing was that in Brussels there are many local shopping centers, and you can find cameras there as well. Okay, this says practically the same, let's keep it. Okay, concerning the future, there is a large plan to put in common all the public cameras. So there's actually the port of Brussels, which has cameras along the canal, also the metro stations, and on metro lines in the vehicles there are also cameras. In the train stations, I mean nearly everywhere, but all of those cameras form a sort of web of surveillance over the city, and there are plans in the future to centralize all this information. It will be all linked together, but it's still under negotiation. But still, the result will be that up to 3,000 cameras could be part of one single network, and the police will have access to it. Yeah. So now conclusion with Pauline.
Okay, I'm going to talk very fast about the results of our comparative analysis. First about the similarities, obviously. So generally the broad logics that underline the spatial distribution of publicly owned cameras in both cities are quite similar, as they both focus on central commercial hubs, residential areas concentrating poor and immigrant population, and police stations. Moreover, we kind of pointed out that there is an increased surveillance of commercial hubs and sensitive residential areas when they actually coexist or are located next to each other. All of this might be, like this similar distribution might be explained by the fact that both cities are in a context of a capitalist globalized economy and increased competition between cities, where making its environment safer is generally part of a city's strategy to attract international and foreign capital. Two other significant similarities are that it is generally the local political authorities that drive the setting and expansion of CCTV networks, and that the police opinion is always a little bit more mitigated, although they always accept the measures when they do not have to fund it themselves. Yes. More interestingly about the differences, in Brussels there is additional surveillance, obviously, if you look at the maps compared to Copenhagen. For example, there is monitoring of the secondary centers and minor commercial streets, which there is not in Copenhagen, not publicly at least. And also, additional sorts of spaces are under surveillance in Brussels, such as non-commercial gathering places, squares, stadiums, demonstration paths, spaces that are watched for their intrinsically important status, such as monuments, government institutions, and also the main roads. It is also very striking that the public CCTV network is almost 6 times more extensive in Brussels than in Copenhagen, and while the network is also currently expanding and about to be integrated in Brussels, it is not the case in Copenhagen since 2012. Therefore, the public CCTV deployment strategy of the 2 cities differ in that there is a dynamic of panopticization in Brussels, while in Copenhagen, the public surveillance is limited in scope. A few possible explanations for such situation might be found in the fact that Brussels has a far more complex and fragmented distribution of power, which could explain the greater number of cameras, because there are also more level of decision making. There is also more blatant inequality, social inequalities in Brussels, which is a situation that allows more for the justification of the setting of cameras. And also there is a greater political and economic interests at stake in Brussels, for example, with the presence of the EU institutions. And also traditionally, the defensive urbanism culture in Copenhagen appears, and in Scandinavia in general, actually appears softer. So to conclude very, very fast, in 1 or 2 sentences, we can say that we found out that the 2 studied capitals were subject to common trends under the neoliberal governance of insecurity in a context of global city competition and diffusion of defensive urbanism.
Do you have any questions on the presentation? Yes, please.
Yeah, first of all, I would like to give you compliments for the presentation. I always like it when it's just pictures and not slides of text. You get the attention to the story more. Nice that you did empirical research. Do you also have did also normative notions come up into your mind, whether it's good or not to have CCTV in certain places, whether certain places are better to have CCTV or not? Or did you just not focus on the normative part, just on the empirical side?
We have actually for our thesis a very extensive theoretical part, like that constitutes almost half of it. So all the matters of ethics and politics and contextualization and were very much developed. We thought that for a presentation it was more interesting to bring up what we actually produce. But of course, I would also say that as any researchers, we have our beliefs, which on one hand we shouldn't bring into research, but on the other hand, we cannot avoid. And I guess we try to give our thesis a political direction by using theoretical authors to speak for us somehow.
And which city is better?
City?
Yeah.
That's a very oriented. I want to say Copenhagen, but because I live there.
Yeah, I mean, our perspective was really in opposition to CCTV surveillance in general, so we didn't come up with advices for the politicians who were to put it on.
Okay.
And also one thing to think about is that in Copenhagen it looks like there is not a lot of cameras, but there actually is. The only difference is that they're privately owned, whether it is by shop or railway companies or stuff like that. And these are not put on the map. This doesn't mean that Copenhagen is not under surveillance, of course.
Okay, thank you very much. Let's move to the next presentation. The floor is yours for just 10 minutes. Sorry for that.
Okay. So hi everybody. My name is Niculescu-Dinca, and I'm a doctoral student at Stockholm University's Institute for Law and Informatics. And the paper that I wrote for this conference was basically a case comment about this action going on in Ireland called Europe versus Facebook. But before I get into the facts of the case, I just want to relay a quick little story. So a couple of years ago, I went to the south of France with my family, to this lovely city called Beslay, and it was right after the news about Prism had broken. And was like I basically had to tell my family, like, I'm gonna go into the study every morning and read all these reports that are coming out, because it's really important to do research. And one of the first things that, like, totally confused me was, like, I just couldn't figure out what legal framework we were talking about. Was it international human rights law? Was it European Data Protection Directive? Was it safe harbor? Was it just US law on FISA? I was a little bit lost. I was very lost. But then I was like, okay, calm down, Leanne. Like, one thing you could do is to try to identify, like, what kind of data transfers are going on in the context of this prison program, because, you know, certain data transfers have certain legal consequences. So I just want to share, I started to draw, like, all sorts of diagrams, and I just want to share 2 of these diagrams with you. Sorry, how do I?
You put here or space bar or whatever. Yeah.
Okay. So the first one is kind of like the dominant narrative. It's like, okay, you have like an EU citizen who gives their data to a company in Europe, and that company is actually a subsidiary of a US company, and then that subsidiary sends the data to the parent company, and then the company either provides some kind of direct access to their servers or some kind of mediated access, and then, you know, the NSA uses it. Another possibility, though, was that like an EU resident just makes their data available online, for example, through a social networking service. And then that data winds up stored on a server in the US, and then the US company either provides some kind of direct or mediated access to the NSA. But I was like, okay, I'm in France, it's really hot down here, drinking a lot of wine, I'm confused, but I'm gonna go back to Sweden and I'm gonna figure this out. So I go back to Sweden, and I spent like a long, cold Swedish winter trying to like work on these issues, and I actually get pregnant, and I don't drink anything for a year, and like my daughter is 7 months old, and I still feel like there's so much gray in this area. So that's why when I heard about this like Europe versus Facebook case, I was like, I need to look at this. This is really important for our research, because maybe we're gonna get some courts, maybe we're gonna get some judicial decisions that like hash out some of this grayness. So with that, I just wanna get into the facts of the case. So just here's a quick picture of like how I see Facebook. You know, it's got European headquarters in Ireland. It's got a subsidiary there too. It's got offices all over Europe. It recently launched a server farm in Sweden, but its main place of business is in California. And until pretty recently, Facebook has said that all of its user data is stored on servers in the US. So basically, what happens in this case is you have this Austrian not-profit organization backed by Max Schrems who comes and says, like, look, Irish DPA, you need to stop the data transfers that are going on between Facebook Ireland to Facebook US. You need to suspend the specific data flow. I get that these transfers are authorized under the Safe Harbor Agreement, but it's not working in this particular context. You have authority under Article 3.1 to suspend the specific data flow, and none of the exceptions apply. And not only do you have obligations like under the Safe Harbor Agreement to suspend this data flow, but you also have obligations under the Data Protection Directive and the European Charter of Fundamental Rights. The Irish Data Protection Commissioner is like, well, sorry, our hands are tied. We're statutorily bound by the 2000 Commission decision that says that all data transfers made by the Safe Harbor Agreement meet the adequacy requirement. The Irish High Court writes like a very thoughtful decision, acknowledges the problems that these transnational surveillance programs present, but ultimately concludes that if the Irish DPA isn't allowed to disregard the Commission's decision, then Europe versus Facebook complaint must fail. So there's a question that's been sent to the European Court of Justice dealing with this. So this case really has so much to do with the power play that's going on between the Commission and the Data Protection Authorities, what rights DPAs have to act directly pursuant to perceived like obligations under the Data Protection Directive and under the European Charter. And I promise that I talk about all these issues in my paper, but because our time is so limited, I'm gonna skip right over that and present an alternate perspective of the case. So if we go back to those two diagrams that I showed in the beginning of the case, at the beginning of my talk, I feel like Max Schramm's bases the decision on the first picture, but I think you could also look at it from the second picture. So instead of asking whether Facebook Ireland is compliant with the directive and looking at the data transfer that goes on between the subsidiary to the parent company and looking at the safe harbor agreement, you could look at whether Facebook Inc. in the US is compliant with the directive when it transfers data to the NSA. So, yeah. This requires looking at Article 4 of the European Data Protection Directive, which during that long, cold Swedish winter, I spent a lot of time trying to get my head around, and it's a really tricky provision. And I basically break it down into 3 parts, but because our time is so limited, I don't think it would, I think I'll just be quick here. The first thing you need to do is ask what kind of processing of personal data has to be examined. Then you've got to see whether or not there's an establishment of the controller in the EU, and then you've got to ask whether the establishment processes personal data, wait for it, in the context of the activities of that establishment. And this is harder than it looks, and I think if we kind of look at Google Spain, we can see the considerable difficulty that one might have when they try to actually apply this provision in a real world context. So as many of you probably know, Google was asked in its capacity as an online search engine, whether it's required to block unwanted data, personal data appearing in search results, right? So the first step, you go, what exact processing of personal data has to be examined? Okay, we're talking about search engine operations. Second step, okay, is there an establishment in the EU? Yeah, Google does have an office in Spain, but it's like set up for marketing and sales purposes. Then you've got to ask, if there is an establishment, does the personal data processing in question take place in the context of the activity of that establishment? 2 minutes, okay. Well, yeah, I guess most of you know that Google said no, Spain is only processing data in the context, Google Spain is only doing processing data in the context of sales and marketing purposes. The European Court of Justice disagrees. It says Google Spain is inextricably linked to Google Inc. search engine. Without the sales and promotion of the online advertising space, the search engine wouldn't be economically profitable. So I think you could use that same exact reasoning here with Facebook, and you could look and you could say that Facebook Ireland, like even if it's an establishment, it provides memberships to users, and that without those memberships, the companies are going to be economically profitable. So the point that I'm trying to make here is that that Facebook Inc. in the US could be Facebook Inc. could be directly accountable under the directive. So what does that mean? Well, if it's directly accountable under the directive pursuant to Article 4, that means that it can only transfer data to the U.S. government if the U.S. government can ensure an adequate level, so long as there's adequate data protection. So you could have like an Irish DPA come and say, like, you know, Facebook, or any DPA could come and say, Facebook, you're in breach of core European data protection principles when you transfer data to the U.S. government, transfer data to the NSA in the context of programs like PRISM. And then Facebook will come back and talk about the public security exceptions, and there's like a huge gray zone right there. What is the public security exception? You need more case law there. It's not clearly defined anywhere. So I guess like the main, I guess one of the main points I want to point out today is just that like you kind of have like 2 roads you could go down if you're a guy like Max Schramm. You could go the adequacy, safe harbor, and the little cheese approach. So you could get to the foreign wrongdoer by imposing restrictions on local EU companies. But I don't know if this is totally fair. You might discourage U.S. companies from setting up establishments in the EU. It might not exactly respect the concept of corporate separate identities. It might be unnecessarily complex. The other road you can go is the Article 4 big enchilada approach, which you could impose they go after the person that you really see as the wrongdoer here. But again, this might not be fair. Like, sure, maybe Facebook knows about the EU Data Protection Directive, but not all the not all the data controllers in the U.S. know about it. So then you're expecting everybody to know about that they're required to adhere to this law, and maybe international laws. Thursday's working by it.
Okay, maybe one question during the time we are switching to the next presentation. No? Yes, quick, please.
Yeah, do you see, will anything change if the current version of was then Article 3 of a regulation? Would that change anything in your analysis of whether it's possible to go for an extraterritoriality approach?
Yeah, I mean, absolutely. I think that it's only going to get the scope of European data protection law is almost going to be unlimited. I would say. I mean, I didn't even talk about Article 4.1c in the regulation. I mean, it's just going to be so broadened that I don't know who's not going to be responsible under EU data protection. I don't know if you agree now. Sorry.
I agree with you. Thanks.
Thank you. I couldn't resist to make a little advertisement. So tomorrow, during the GRC session, Max will intervene in the session at 2 o'clock, Petite Halle. Please, the floor is yours, Niklas.
Yeah, thank you. Yeah, my name is Niklas. As you can see, I'm from Technical University of Berlin. And I would like to talk about a case study that we conducted in a project called Profiling. And I will touch some of the points Vlad talked about before. That was quite interesting for me. Because the case study was about the use of databases and data analysis tools by German police to monitor political activism to combat politically motivated crime or political extremism. So we conducted 8 expert interviews with police representatives, with representatives of companies which supply German police with data analysis software, with legal experts and political activists who were affected by police measures. And then we backed it up with a literature review because you can see the sample was kind of small, so we wanted some more information there. Yeah, I'd like to give you just a brief idea of how police use database in Germany, how they use data analysis tools, and how that then affects policing. When we talk about police databases about politically motivated crime in Germany, it's important to mention a quite young trend, which are so-called joint files. And joint files are databases which are centrally run and maintained by the German Federal Police, the Bundeskriminalamt, BKA. But the data that goes in there is provided by the 16 state police in Germany, and other agencies depending on the specific database. And all this data in there is then also accessible for all the involved parties. And that is kind of new because before these databases, the exchange of data was more restricted due to the federal structure of German police agencies. When it comes to politically motivated crime, there are various databases on various levels, on the state level, also on the federal level, and they cover distinct political fields usually. So we have a database, politically motivated crime left, right, foreigners, counterterrorism database, right-wing extremism databases, and so on. And these databases differ regarding which exact information can be stored, which purpose they have, whose data can be stored, but in general they share a common purpose, which is on the one hand criminal prosecution, that's classic, but then what is more important, growing important, they serve preventive purposes. And for these prevention purposes, the database are supposed to help to identify networks, structures, they are supposed to identify dynamics of political scenes and relevant persons and relevant organizations here. So then there's data stored about persons, institutions, locations, about events, about objects, and so on. And it's important to mention that the databases do not only hold data which is obtained in criminal investigations, but there are, especially in the political context, there are many occasions which can result in one's data being stored in database, and that these are often sub-criminal occasions. For instance, it could be an encounter with police at a demonstration, which includes routinely personal identification. The data can then be kept in the databases if a person is assessed as being dangerous, which means being likely to commit a serious offense in the future. And beyond that, data can also be stored of contact persons, data can be stored of companions, data can be stored of supporters and supporters of groups or persons which have been assessed as being dangerous. So there's quite a large set of data that can be stored, and it's a quite large field of persons and groups who might be a subject of police data gathering here. And then to put all this information into the database, it of course needs to be itemized according to the respective database categories, to be made accessible all over Germany, to be made analyzable, comparable. And this is a process of decontextualization. And then the recontextualization is done by the data analysis tools. There are several data analysis tools in use in Germany, but they usually do the same thing. They interlink elements from various databases as connecting the dots to identify structures, dynamics, persons, groups, and their relevance and roles in political structures. And I'd like to give you an idea what this looks like. It's unfortunately in German, but I hope it gives an idea. This image doesn't look like much, but it's an image that shows information which the BKA, the German Federal Police, gave to a person who had requested information about which data of his was stored by the German Federal Police, and after 2 years of trials and court trials, he got the data, the information about which data was stored. Before that, the police refused to hand out that information. And here it doesn't look like much, but you can see him in the middle, and then he's allocated to 3 demonstrations about repression and anti-militarism. He is listed as an organizer of these demonstrations. He's allocated as a member to an institution, and then he's allocated to his home address. Doesn't look like much, but these items can then turn into nodes, into structures which can be potentially complex. This is, I think, on the IBM Analyst's notebook homepage, and that is what these structures can look like when, after a database query, there's some supplementary information too. So this is what these only small pieces of information can be turned into. And what we see is they are recontextualized into single items, but they're still out of their narrative context. But still, these visualizations are used to build thesis on them about the suspiciousness and the dangerousness of persons and the relevance and roles of persons and groups in political scenes. To then be able to address them with police measures, such as, or to initiate investigations. And here the danger is that we can see a shift regarding what is considered as evident to assess someone's suspiciousness or dangerousness. Because now that there's so much information available and from so many various sources, it's harder to assess the reliability, the validity, and the meaning of single pieces of information, so that the meaning of information can easily be misinterpreted when it is presented in such a, let's say, persuasive manner here. And that doesn't mean that these visualizations determine which theses are built on them, but they favor certain paths of interpretation, so to speak. In the context of politically motivated crime, that can mean that legitimate political activities like organizing demonstrations, attending demonstrations, publishing in certain platforms, maybe visiting a mosque or something like that, can become ground for addressing persons with police measures like reporting obligations or travel bans to prevent people from attending certain demonstrations, or maybe intensify police surveillance. So the problem here is that the separation between what's legitimate and what's illegitimate political activities blurs, and that the field of what is considered as dangerous or crime-ify is somehow expanded. Yeah, I'm aware, yes, thank you. So these databases and data analysis tools, they allow to identify structures and persons and groups and dynamics as connected dots, and by that they render these structures as subject of police knowledge and police practice. And by that they are made governable, as they can be addressed with police measures. And this governable field is expanding due to the capacities of databases and data analysis tools, but it's expanding by rather uncertain information due to the fact that it's harder to assess what information means, if they're valid, if they're reliable, and so on. So this network orientation then benefits a preventive approach and a growing need to gather data, as it enables to monitor social fields and their dynamics, And here policing increasingly resembles what usually would be activities that domestic secret services would carry out. And also because police activities in this pre-crime area, especially against the backdrop of the use of digital information, becomes more and more opaque. And here databases seem to constitute something like a persistent space of an abstract suspiciousness which can be flexibly and context-dependently activated by database queries. And that is why I'm actually on the same page as Vlad, because here our thought was too that it is important to understand the construction of suspiciousness if you want to understand policing, because suspiciousness somehow defines, or the concept which defines which segments of the population can be made accessible or addressable with police measures, who can be rendered as subject to police measures. And here it is, same thing as you said, I think crucial to understand how does technology and human activity interplay, and which kind of knowledge, which kind of practices, and which kind of power unfolds in this interplay of technology and human activities. Yeah, these were the questions which were interesting for us, but you might have.
One question, we switch to the last presentation. Last but not least, of course.
I will have
Yes.
more, but I will go in detail later.
Yeah,
if you
okay,
don't mind.
Yeah, okay,
Yeah.
it's your turn. Just keep in mind that you are between us and the cocktail, so that's
Don't worry,
a challenge.
Yeah, I can do this in 2 minutes. The first one.
This one, okay.
Thank you. Well, as you probably guessed, I'm Ignacio Cofone, and I'm from the European Doctorate in Non-Economics, and I'm here to talk to you about well, privacy and innovation and how privacy relates to the flow of information. So I want to start with a very colorful quote by Keersmaecker, who's a very prominent information economist, and this is a big block of text just for burnout. And well, he says, I'm going to read fast. Recently, a new territory has been discovered by economists, the intellectual content we call privacy. The pioneers are peerless leaders, Boster and Spiegler, whose golden findings have dazzled the world. It's high time for Rattlers and Esperados, the rest of us, to put in an appearance. Of course, I have to add parenthetically, new is relative to one's point of view, because our pioneer economists found aborigines already inhabiting the territory. In this case, intellectual primitives like Supreme Court justices and such. Quite properly, our experts have brushed the natives aside. So, why this quote is wonderful is because Keersmaecker is actually not being sarcastic, and the rest of the article, which is less colorful than the quote, brushes the...
In 5 minutes.
Okay.
Enjoy your evening.
Yeah.
So I'm going to be really fast.
It's a flexible 5 minutes.
So what did all these colonizer economists said about privacy? Why do we have privacy? Well, they said that what privacy does is to create information asymmetry between two people. If I'm an employee and I have a right to privacy and then I'm interviewing with the employer, what privacy law does is to allow me to not disclose things about myself that he might want to know. So we're creating an inequality between two people. And to that, they complement that to privacy, the Coase theorem applies. What is the Coase theorem? Can I borrow your pen?
Yeah, sure. Like mine, but
Okay, great. So imagine that we have this pen, and then both Pauline and I want to use this pen. So we have this benevolent dictator or policymaker or whatever mental exercise you prefer that has to decide who owns the pen. What the Coase theorem says is that if Pauline values the pen in 3 euros and I value it in 2 euros, then imagine that Pauline owns the pen. Then I will not buy it from her because I'm only willing to pay 2, and the minimum that she's willing to accept for the pen is 3, because that's not how much you value it, right? And then, so you end up having the pen. But if the policymaker gives me the pen and you value it in 3, you'll tell me, hey, you want 250 for the pen, because you'll be happy because you value it in 3. And that's yes, and I'll give it to you because I value it in 2, so 250 is better for me. So whoever we allocate the right of something to is irrelevant in the sense of who will have that right in the last place. It's only relevant on distribution of monetary effect. So if we apply this to privacy, or this economist always said, then it is irrelevant who we give the right of the information. So if we have privacy or we don't have privacy, because people will end up knowing the same in either case. We'll just have distributional effects. And then they go to say that the privacy tort is still efficient because it actually increases the disclosure of information by prohibiting eavesdropping and all these nasty things that are very, very costly to pursue. But then the Rasters and Desperados game that Hirschläfer liked so much, and they said, well, this is not entirely right, because well, privacy is about exclusion versus disclosure. Do we put the default on exclusion of others from personal information, or do we put the default in disclosure of personal information? And there are lots of externalities in personal information. Every time we give our information to Facebook, and then Facebook sells that information, well, first of all, Facebook doesn't sell the information, but if it did, to other companies, then there would be an expected cost in the form of a privacy breach for us. We don't control how that information goes around, but the way in which that information goes around affects us. And in addition, there is a test for privacy. We don't only care about privacy to deceive others, to be employed by people even though we would be bad employees. We care about privacy because there are things that are close to us that we don't want other people to know. Many people don't like posting pictures of their children on Facebook. Many people don't want the government reading their private conversations with their partners, etc. However, what they even explained is that even if all this is true, if it is clear who owns the information and it is easy to transact, the information should end up in the hands of the same person. So to see who of those sides ended up being right, we can see which are some of the main data protection rights, at least in Europe, that I will not go through now, but the right to know, the right to access, the right to rectify, the right to refuse to object, and mainly the right to be forgotten, if we have one after Google in Spain, are mainly about excluding other people of our personal information. They don't constitute, at least prima facie, a full-blown property right. They don't constitute ownership of our information, but they do allow us to exclude other people from our personal information. And the same goes for the main concepts of privacy that I actually would love to run with our previous speakers some point in time. These are the 6 main definitions, at least in the legal literature, that are considered privacy: the right to be left alone, autonomy, secrecy, control of personal information, personal and intimacy. All of them also include as a main element to be able to exclude other people from our personal information. So what happens with this inclusion? Well, there is not zero protection of privacy as the first economists seem to have predicted that would be the efficient system. But at the same time, there's not a full-blown property right as the second stream of economics said that there should be as an efficient protection. So what can explain this? Well, we can take into account, regarding the cost here, regarding that this irrelevance of who we give the rights to, personal information is special in some sense. And that sense is that when we deal with personal information, especially in the context of data mining and social networks, we're dealing with information that is not yet created. So personal information is not so much about the bank, that you have to choose who owns it, the person or the company, but it's more like one of the many goods that we have available, IP for example, that we have to decide how much incentives to put on its production if we want to increase information flow. So imagine that you have a farmer who owns a cow, and then you have a supermarket. And then you have the same situation as before with the pen. You have to decide the milk that will be extracted from the cow, so that doesn't exist yet. Who do you give it to, the farmer or the supermarket? Because according to the theorem, it would be the same, because it would go to the highest value in any case. But then you see that if you give the right to the farmer, then the farmer will take out the milk, it will sell it to the supermarket, who's the highest valuer, and the farmer will get the money. However, if you say, as an issue of policy, every milk that comes out of the cow will go directly to supermarkets to save the middleman, then the cow will never milk. The farmer will not have incentives to milk the cow. No one will invest in extracting that resource. And the same goes to some degree for personal information. In social networks, we get some benefit out of interacting with the social networks and giving our information. In data mining, the person that does the data mining gets some benefit out of creating that new information. And that benefit exists because we have these rights to exclusion that are, to a certain extent, limited. But if we didn't have them, if it was overall and anyone could use any information, then we would have no reasons to produce this information. We have no reasons to invest and engage in these expected privacy costs. So there are different ways of doing this. One of the main ways and easiest ways is to create full-blown property rights, so create ownership on personal information. And this will have several benefits that I'm not going to go through now, so we get to the coffee break. But it also creates several costs. It mainly creates a moral hazard problem, that is, companies exposed, if they already paid for the information, they would not have incentive to take care, because if they're not liable for what they do because they already compensated ex ante, they already bought it, then why would they engage in protection? And then the people would suffer the cost of that information anyway. And then there is under protection for data mining when the pieces of data are owned by different people. So to conclude, what does it say? Well, this leads to a consequentialist argument in defense of privacy that is different from the arguments that were made so far. Many of you might have very different reasons to support privacy. But well, the beauty of this, I think, is when we get to a consequentialist analysis that overlaps with the natural extension of taking autonomy and taking the rights of people seriously. The consequentialist argument is that data protection actually can increase information flow. It is not always true that privacy and information flow are two opposite things, and we have to balance how much information we have around versus how much privacy we have for people. It's not a social welfare versus individual rights sort of debate. And this allows us to have a framework for evaluating data protection law within economics, basing data protection law on the concept of exclusion rights. And it leaves two open questions. The first one, what is an efficient level of data protection? Which one should expect should have sort of a concave function in which we don't want either zero protection or ownership, but something in the middle. And the second, is there a trend towards more property or more exclusion over data? Thank you very much, and I'd love to hear any remarks that you might have.
Thank you, Ignacio. 1-2 questions maximum regarding the presentation. Nothing, you are just singing about the cocktail?
So am I. So.
Yeah, okay, right. Okay, please join me to thank again the speakers for their knowledge.